Hi, welcome to Oregon State University's 2021 Constitution Day. My name is Christopher Nichols. I'm a historian here at Oregon State University, director of the OSU Center for the Humanities, and founder and director of OSU's Citizenship and Crisis Initiative. I'm really honored and pleased to be with you moderating and helping to organize today. Normally we gather in person, we have food and drink. Sometimes we're able to take the whole panel out for cocktails afterwards. And alas, in year 2 of the pandemic, that is still not happening for us, unfortunately. But we're here together to talk about some of the most important issues the last year plus has really brought up, I think, and to use a constitutional lens to give us some stability in thinking through those questions. So we're here today for Constitution Day. As you may know, all educational institutions in the US that receive federal funding are required by law to hold educational programming pertaining to the US Constitution. That's because on this day, in September 17th, 1787, in Philadelphia, Pennsylvania, the US Constitution was signed by a whopping 39 people who changed the course of US, obviously, and world history. Those and related actions are in significant measure, in totality, perhaps, why we're here. It's instructive, I think, to consider a little bit the history of this day as we get going. I like to mention this as we go so people have some sense of why we're doing this and where it comes from. Days honoring citizenship and the Constitution in various cities and states have been traced back to at least about 1911 and into the 19th century in some other cases. Changes in this as a specific day of celebration track neatly with major conflicts of the 20th and into the 21st centuries, which is interesting to note. And I recommend you think about that as we think about questions of individual rights and collective responsibilities. The first widely observed events of this type came in 1939, no shock, with World War II on the horizon, with the first day celebrated by joint resolution of Congress in 1940. Then throughout the war, the third Sunday in May was designated I Am an American Day, a sort of hyper-patriotic wartime celebration. This was followed in the late 1940s and into the Cold War with similar kinds of events, often anti-communist domestic politics, which were mixed with a Cold War military and diplomatic kind of sensibility, really heralding the US Constitution and American democracy of the kind of apex of world history. State-level proclamations also proliferated around Constitution Day, mostly by governors and state legislatures, eventually making September 7th I Am American Day in virtually every state. In turn, between 1949 and 1952, most states softened this language slightly, and they started changing it to Citizenship Day to try to pull more people into it. In 1952, this went national and shifted on September 17th, when President Truman proclaimed the first Citizenship Day, July 25th, 1952, making September 17th Citizenship Day. An act of Congress then pushed this in some new directions. I could walk you through a lot of this, but I'll just kind of summarize a little bit. In the 50s, Dwight Eisenhower pushed forward a constitutional week from September 17th to 25th. And there were a number more permutations throughout the Cold War. This really remained until Citizenship Day and Constitution Week were enacted by Bill Clinton in the year 2000. And our current observation stems from a 2004 amendment by Senator Robert Byrd of West Virginia that in addition to renaming the holiday Constitution Day and Citizenship Day, enacted by Byrd and signed into law by George Bush, active as of 2005, that's when this mandate started, that all publicly funded educational institutions and all federal agencies provide educational programming on the history of the American Constitution and themes thereof. Okay, so here we are. We're fortunate because Oregon State University takes this seriously, but also allows us, scholars, faculty, teachers, some room to focus our theme on different themes and to approach this through our expertise. I'm pleased to be joined by 4 fantastic scholars. The theme today was selected out of conversations with a large group of faculty at OSU, and obviously it keeps COVID-related questions firmly in mind. Things that have come up lately that seem to have perplexed all of us, including some of the scholars on this panel, perhaps all of us on the panel. I should add up front that as a historian, one of my areas of specialty is the 1918 flu pandemic. I'm not going to make any comments on that, but we could talk a little bit about individual rights and collective responsibilities in the pandemic 100 years ago. So we've got our hands full, and I'd love to jump right into our speakers. So The basic format is that each speaker will have 10 and a maximum of 12 minutes to speak with some provocative thoughts, nothing too comprehensive, but some material to get us going. And we're eager for you all to also add your comments and questions in the Q&A box or in the chat. And then we're anticipating a vibrant discussion of these really important hot button issues and topics. One of the things that we always emphasize, especially when we're in person, is just how important community conversation is about issues like this. And Oregon State University and those of us on the panel take our land-grant public mission to heart. So please do engage, throw some questions at us. We're eager to hear your thoughts. So first up, we've got Professor Rory Spill-Solberg, one of my favorite collaborators on Constitution Day and lots of other kinds of events and activities. She's an associate professor in political science in the School of Public Policy in the College of Liberal Arts, scholar of judicial politics and judicial behavior, widely published in scholarly journals such as the Journal of Empirical Legal Studies, Social Science Quarterly, Policy Studies Journal, Political Research Quarterly, Justice Systems Journal. I think her most recent book, if I'm not wrong, co-authored with Eric Waltenberg on the media, the court, and misrepresentation, examines media coverage of the Supreme Court, arguing that the coverage has changed, and now the court and the justice are covered far more similarly to other political institutions, really to the detriment of the court and its legitimacy. At least that's my view, and I think that's hers. We'll see what she says. As I understand it, she's also working on a number of new projects, including on issues of female judicial candidates and on judicial nominees and diversity of the bench. And she'll be helping us really set the stage for what these main questions are related to individual rights and collective responsibilities, sort of in a legal framework, and also in terms of the hot button issues that are presenting us today. And I'll introduce each of the other speakers in turn. So please help me welcome Professor Rory Solberg.
Thank you, Chris. Thanks for inviting me today. All right. So welcome once again to Constitution Day. Thank you all for taking time on this Friday afternoon. The topic and the prompts that Chris sent us to prepare for today are really, they're very timely, but they're also in some senses timeless and sit at the heart of our constitutional republic. I'm going to do my best to kind of address and sort of set the table for these questions, but recognizing that there really are no simple answers, and we could spend a lot more than 10 to 12 minutes talking about each of these. So two of the questions that Chris presented to us were, what rights are we granted by our Constitution? And to what extent are those rights abrogated by social needs? And have the constitutional principles related to that balance between rights and responsibilities changed over time? So I'm going to try to set the table with those two questions, answering them in my brief time and at a fairly vague level, and then allow my learned colleagues to sort of drill down to their specific interests. So in terms of the first question, most people do think they have a pretty good handle on what rights we have. But in truth, a lot of the rights that we think we have or we espouse that we have aren't actually in the document. So it's always a good idea to kind of briefly go over exactly what the Constitution says versus what we believe it encompasses, right? So we have a right to speech. We have the right to exercise our religion and the right to assembly. We have the right to bear arms, which has been interpreted more recently as an individual right to self-defense. We have a right to be secure in our persons, houses, papers, and effects. We have a right to remain silent in criminal procedures. We have a right to due process. We have a right to equal protection under the law. We have a right to a speedy and public trial, an impartial jury, and the right to confront and compel witnesses during those proceedings. And that's really about it, for rights that were explicitly stated, positive rights in the Constitution. There are also some prohibitions placed on government action that relate to individual rights. For example, government can't establish a religion, nor can they force you to quarter soldiers in your home. Government can't search or seize your property or your person without a warrant in most instances. Government can't try you twice for the same crime or try you, at least at the federal level, without a grand jury. And government can't take your property without compensation. It can't levy excessive fines or use cruel and unusual punishments. And finally, in most cases, government can't abridge habeas corpus, nor can it write bills of attainder or ex post facto laws. And finally, can't really deny you your privileges and immunities, although those are not spelled out, nor are they interpreted widely in constitutional law over the course of our history. So that sort of answers that first question in a very basic way. But much of what we consider to be our rights are also those rights that have been interpreted from those rights that I've already mentioned, those explicitly written in the Constitution, or rights implied from those, things like your right to free expression comes out of the right to free speech, or your right to privacy, which is interpreted to be implied from the penumbras and emanations formed by all of our other rights. So these are rights that are, determined to be supported by parts of the Constitution and then codified in precedent by the Supreme Court. So those are some other rights we have. And then there are also rights that are granted to us by government. I would call them statutory rights, rights that the federal government gives us through law by using the powers granted to the federal government by the Constitution to then guarantee additional rights. So, for example, I have on the slide a right to a free and appropriate education. So what we end up having, particularly in our current time period, is a situation where we have conflicting rights and trying to figure out how things balance, right? So if we use our example of the pandemic and COVID as a starting point, we have, under the Rehabilitation Act of 1973, students with disabilities in schools that receive federal funding are guaranteed by that statute, by the federal government, a free and appropriate education. This is a right, again, created by federal law and enforced, such as it is, by the federal government. It's not a right written in the document, but one, again, granted through the application of other powers. So it was announced at the beginning of last week that the US Department of Education is actually investigating whether some states that have mask bans in schools, and that's Iowa, Oklahoma, South Carolina, Tennessee, I'm checking my notes, and Utah, are violating the rights, the civil rights of students with disabilities who are at a heightened risk for contracting COVID and the Delta variant, right? So are they being denied a free and appropriate education? So you have, again, conflicting rights in this situation: the right of parents to rear their children as they see fit, or perhaps the right to practice your religion, is in conflict with the right of students with disabilities to get a free and appropriate education. So how do we determine which right wins this conflict, right? This is sort of at the heart of our talk for today, right? How do we deal with this kind of conflict? Now, in this situation, each interest claimed the right to rear your children, your right to free exercise of religion, and your right to free and fair and appropriate education can all be linked back to a constitutional authority, either directly or implicitly, okay? But the Constitution actually provides very few directives on how to deal with these conflicts, particularly when rights are on an equal footing. There is really no hierarchy of rights currently in doctrine, although there used to be. Earlier in the 20th century, the Supreme Court declared that some rights were so fundamental to our concepts of ordered liberty that they then needed to be applied to not only the federal government, but applied down to the states. And so that was the fundamental freedoms doctrine. And those rights were considered, sort of on an honor roll of rights and were given special constitutional consideration. It was harder to abridge those rights. But at this point in time, in our current context, almost all of the Bill of Rights has been applied down to the states. So pretty much almost all of it, save a couple of clauses at this point, are not considered fundamental freedoms, have not been applied down to the states. So that hierarchy that was determined has kind of faded away, at least as a way to make a distinction between rights. The supremacy clause perhaps can provide us some direction, because when a mere law conflicts with the Constitution, we know the Constitution wins, right? When a state law conflicts with a federal law, the state law loses, right? The supremacy clause sort of sets up that hierarchy of law, but it doesn't tell us what to do when two rights are on, again, an equal footing, both coming or derived from the Constitution. But we could look at these rights and that I mentioned in the previous slide and say, well, the right to free exercise of religion is explicitly placed in the Constitution, where the right to a free and appropriate education is kind of one step removed. It's from a power of Congress that then provides you with the right. I'm not suggesting that I buy that premise, nor that you should use that premise, but it is somewhat problematic, right? Because, the free and appropriate education is from the Constitution as well. It's a direct, explicit power of Congress under the necessary and proper clause to enact those powers. So I think it's tough to say that one is more directly linked or not to the Constitution, but other people can disagree. So again, we don't have a particularly good answer, at least currently in constitutional law or doctrine. The truth of the matter is that when rights conflict, a lot depends on the context and the court, right? Who's sitting on the court and what values does society at that point place higher? Even though some of the Constitution is in fairly absolutist language, right? Congress shall make no law abridging your freedom of speech, your free exercise of religion. The reality is no court, supreme or otherwise, has ever interpreted that absolutely, right? Courts have always balanced the interests of society, the interests of government against our individual rights, right? Or to use Chris's sort of eloquent language that he sent to us, whether governments, state or national, have been able to abrogate those rights if societal need is high enough. It's always been that way, right? So even if you have a right to rear your children as you see fit under the right to privacy, right? So you don't want your children to wear masks. The national government and state governments have always had the ability to infringe on those rights to accomplish their job as government to protect society, to protect the general welfare, provided they meet the jurisprudential test of the times, okay? So what is that standard? I'm hoping I have enough time to go through this. So when we're discussing your free exercise of religion or any other right, much of the jurisprudence wasn't really developed until the mid-20th century. But in general, as long as government doesn't target a right, doesn't strike at the heart of that right, then any incidental burdens are allowed. So for example, if your religion asks you to, or requires you to proselytize on the street and you want to stand around and hand out pamphlets, the city, the state, the federal government is allowed to say, well, you need to get a permit. And as long as they don't say which religions are okay for pamphleting and which aren't, they just have a blanket law that everybody has to get a permit, then that's an incidental burden on a religion and it's allowed. Similarly, if your religion says you need to take hallucinogenic drugs and we have a national law that says hallucinogenic drugs are illegal, you don't get to take them and get a buy or a pass on general laws of applicability regarding hallucinogenic drugs because you say, well, my religion demands it, because it's a general law and it's not targeting a religion, or at least that's how the Supreme Court sees it. Similarly, if the government makes it illegal to burn your draft card, or for today, your registration acknowledgement card, and you do so in a big political protest, you can still be arrested, you can still be fined for destroying that card, because again, the government is pursuing the draft, pursuing their ability to make war under the Constitution, and it's an incidental burden on your right to protest, to your right to free speech. But if a law then targets religion, then the court subjects it to a higher test, and government can only infringe on that right if it is a compelling interest of government, and they do so in the least restrictive means, if it's a really narrowly tailored law, right? And most laws cannot pass this test. This test is very protective of our individual liberties. But for example, in 1974, the Supreme Court ruled that the federal government could limit our individual contributions to campaigns in pursuit of the interest of free and fair elections and legitimacy of elections. And that the essentially basic cap of how much you could give to any one candidate was the least restrictive means of protecting that interest. And this is a test called strict scrutiny, and again, very difficult to overcome. Now, over the course of the pandemic, the Supreme Court has heard several cases dealing with restrictions on religious liberties, both on its regular docket and its shadow docket, which you might have been hearing some discussion about that. And we can talk more about that later. And these are all related to various policies enacted by governors or states to quash the pandemic. Those decisions, combined with the recent case of Fulton versus City of Philadelphia in 2021, which was about whether the City of Philadelphia, in pursuit of its non-discrimination law, could deny a contract for social services to a Catholic organization. That decision, which said no, Philadelphia couldn't, really gets at the heart of a lot of this conflict. Again, this idea of what is, your right to free exercise, your right to rear your children versus the government's interest in protecting from discrimination or protecting the health and safety and welfare of the public. Okay, so these decisions, again, the COVID decisions and this Fulton decision, the Philadelphia decision, really seem to be suggesting that the tests are changing, that balance is changing. And we've seen a lot of punditry talking about this. And so I want to just kind of end with this so you can sort of see where we are today and how it differs. In a lot of the COVID cases, and again, in the Philadelphia case, the court told the state, told government that they couldn't meet the standard to allow these public health infringements on religious liberty, or they couldn't, their anti-discrimination interest wasn't sufficient to infringe on religious liberty in the case of Philadelphia, but not because of meeting that strict scrutiny test, but because of a sort of a new interpretation that we're seeing, that a lot of pundits are talking about, that freedom of religion is being given what we call sort of a most favored right, as in a most favored nation status. So we're again seeing sort of a hierarchy, that free exercise of religion is up higher than all the other rights in these decisions. And essentially the court is saying in these cases, you must treat religious entities and religious exercise as well as you treat anybody else. So if you have a law that says, Home Depot can be open because with 300 people in the store, then you must also allow religious services with up to 300 people. right? That even if the equivalencies between the entities don't seem quite on par, the free exercise clause requires that it be that way. And the Philadelphia case goes a little bit further and says, if the laws allow for any exemptions, whether they've been granted or not, then you have to have a religious exemption. And that, again, plays to our COVID example with the idea that if you have a vaccine mandate and you have an exemption for anything, a medical exemption, for example, then the court seems to be suggesting then you must also have a religious exemption. And we haven't seen anything like that for any other right. And so the balance seems to be tipping very much in favor of the individual's right of exercise. So again, the court in these cases on COVID and in Philadelphia did not rely on the doctrine that they've been using for almost 100 years. They seem to create something new. And that's my rather long-winded answer to what rights do we have, when those rights can fall to the public or common good, and whether that standard has been changing. How's my time?
Great. Thanks very much. Yeah, perfect way to set us off and set us up. So with that, I will just jump into our next speaker. Our next speaker is Ben Mutchler, an associate professor of history in the School of History, Philosophy, and Religion in the College of Liberal Arts. His research and teaching interests include colonial and revolutionary era America, the history of families and households, the history of poverty and welfare, disease. His most recent book is related to history of disability, the province of affliction, illness, and the making of early New England, from Chicago University Press 2020, on some of the ways in which the routine presence of illness in everyday life shaped and strained the most basic institutions of 18th century New England. And he's also working on an exciting new project in which discussions of citizenship in the era of the American Revolution engaged with questions of ability and disability. And some of these are core sorts of questions related to the public good and individual rights and responsibilities. So with that, please help me welcome Professor Ben Mutchler.
Thanks so much, Chris, and great to be with you and all. And to the audience out there, just a second, what Chris has said, we welcome your questions. One of the nice things about Constitution Day is it draws on different disciplines and has different approaches. And so I'll be bringing a historical approach to this question and digging in more deeply around a particular part of the Constitution that's come into play with reference to disease and public health over time, namely the general welfare provision. And I'll go back even before the Constitution and dig in there, trying to explain how and why it is that this earlier sort of sentiment about the protection of the public and public health finds its way very strongly into the purview of state governance in the 19th century, something I won't take up in detail, but that I will suggest. So we're looking at the general welfare provision. It appears twice in the Constitution, first in the preamble, that suggests that one of the things government should do is promote the general welfare. And then in Article 1, Section 8, Clause 1, that suggests that Congress, so this is specifying Congress's powers, will be able to provide for the common defense and general welfare of the United States. And that's part of a larger provision regarding taxation. Now, as somebody that studies the debates around the Constitution, one thing to emphasize for us is that this is a moving target. There's no sort of steady set of meanings. There's things that are cobbled together over time. Often things happen in a serendipitous fashion, and that's true of the general welfare provision, particularly as it appears in Article 1. That winds up being written very late in the process, late in the summer of 1787. And it's done by one of the great committees on the Constitution, the Committee on Postponed Parts. That's a committee I'd like to belong to. And it comes into play, Madison, who's on that committee, says sort of silently, no big fanfare that's there. And, you know, one of the reasons for that is that the general welfare, the protection of that, is something that applies more broadly to governance in this era, whether it's monarchical or small r Republican. The king and the monarch is supposed to protect the people And in exchange for protecting them broadly in all sorts of ways, the subjects owe the king their allegiance. And similarly, in a republican form of government, people give up a certain amount of their own power over their lives, gives it to their governors so that their governors can protect the people's interests. So it's not surprising that during this year of 1787-88, as the Constitution is being discussed and debated and people are deciding whether to ratify it or not, that there's a sort of casual reference to the idea that government, one of the things government should do is apply to the welfare of the people, that it should protect it. And yet there's concern here. The Anti-Federalists raised this. They said, no, this seems like an unusually capacious term. What does the general welfare mean? Can Congress, for example, in promoting it, suggest that other kinds of rights can be abridged? For example, the freedom of speech. If people are writing in the newspaper that they don't want to be taxed and Congress can tax and wants to devise a tax, is that something that can be truncated in any fashion? The Federalists answer, no, this really has very much to do not being broadly construed. It has to do with taxing power itself. It has to apply broadly to all the states. It can't be narrow and provincial. And they generally tend to dismiss these sorts of concerns. Madison later regrets this, that he thinks they should have really enumerated much more carefully what the general welfare meant. And he sees others like Hamilton run forward with a kind of nationalist agenda, creating a very strong central government, especially with reference to fiscal policy. And he worries about that in the 1830s. Now, when we turn to the states and the general welfare, there's a much longer history that I want to attend to here. And I think it's something that could be useful in our public discourse today, something certainly that we don't have in view, because there is a long history that winds up making its way into the 19th century, where there's all sorts of provisions that states use to protect the general welfare, specifically with reference to health and public health, that has its roots much earlier. And so let's turn to 17th century New England, where it's most visible. That idea there of the protecting of the public and public health comes from this idea of a Christian commonwealth, the New Englanders trying to establish godly communities. And we see one of the strongest expressions of this in 1630 with John Winthrop, future governor of the Massachusetts Bay Colony, and his famous lay sermon, The Model of Christian Charity. If you don't know this off the top of your head, you've probably heard it before. It culminates with the rousing statement that New England should be as a city upon a hill, something that we often hear referred to in our political times. Today, when people refer to it, they often do it in a kind of triumphalist way. This is American exceptionalism. America is the protector and purveyor of individual rights, sort of looking forward and leading the world in this way. But that's a misreading of this sentiment at the time. It was one that was written with great humility and fear, and largely one where Winthrop is afraid of failure. The eyes of the world were upon New England, and the notion was if they failed, they would bring shame upon their God. And there was a lot that they could fail with because the stakes were very high as Winthrop carved them, and they have reference here to the obligations that we owe each other. And so our topic today. Winthrop says again and again that there needs to be a community that's created here where we relinquish our individual objectives, our superfluities, as he says, our luxuries, so that everybody can have their necessities met, where the public will oversway the private. And he says that we need to do this especially with reference to what he calls a community of peril, a term that I think we might want to resuscitate in our day now. That is, my suffering today will be your suffering tomorrow. We invest in each other knowing that in this world, we will all face something. It may be disease, and therefore it has implications for public health. It may be fire, it may be famine, it may be accidents, maybe anything else. They go humbly in that world and understand that none of us control our own fate, and our best protection is through each other and for looking out through each other. Now, we don't need to romanticize this in terms of thinking about community as kumbaya and everybody's getting along. New Englanders saw each other often in the courts, nor do we have to think about community as meaning any kind of egalitarian society. It was a sharply hierarchical society. where superiors were supposed to protect subordinates. Subordinates owed their allegiance, but there was a rank system, and there were many people cast at the very bottom of that society, not least of which were a small enslaved population and Native Americans in this period. But these provisions made economic sense at the time. I'll talk about that in a minute. And they made sense in terms of thinking about how to survive when various sorts of infectious diseases swept through places like New England, as they did repeatedly through the 17th and 18th century. And so what was asked of New Englanders in these cases? Well, they devised early on very strict laws regarding the public health. There were quarantine laws suggesting that ships needed to be inspected before they could arrive in ports and held there for long periods of time. These get elaborated over the 17th century, and by the 18th century, there's an island in Boston Harbor and then another one where ships are held for long periods, sometimes upsetting ship captains. There was also regulations about who could enter a town. And once somebody entered a town, if they were suspected of harboring illness, they needed to be reported immediately. Or if illness was suspected in one's own family or their neighbor's family, this would be reported. In other words, there were surveillance measures. And then if this could be documented, that in fact somebody was ill, especially this applied to smallpox, but other kinds of diseases that they considered that were infectious, people would be ordered to remain in their house or forcibly removed from their house and put into a pest house. Guards were put outside of all of these, red flags flown to indicate that there was somebody sick within, nurses that were impressed and made to serve the people that were sick. And then people needed to remain there for a long period of time, as much as a month. And once they reemerged, they were asked to pay for their care as best as they could, unless they were impoverished. In other words, they asked an enormous amount of people in this period. Now, it made good economic sense to do so. You know, the economy could get revived and not suffer as much if you could say, well, we have this under control. Here are the measures we're taking, and newspapers advertised such measures widely. And people took an individual hit, but as a collective, this enabled the economy to move forward. It also made good community sense. If people could walk around infecting one another, many more people would get sick, and everyone knew that was the case. Now, we might expect in a revolutionary era, as we move forward into the 18th century, where people are rioting over such things as taxation without representation. In Massachusetts, famously surrounding the house of the would-be stamp collector in 1765 and burning the beheaded effigy of that collector, terrorizing him and others into not collecting the taxes. You'd think that there would be resistance to these measures, but I've looked at this carefully, and there's generally not. In general, while there's all sorts of small infractions, the big picture is compliance. There is one exception to this, which is around inoculation, the intentional infecting of the healthy with some matter from the sick through incision in their arm or leg, and with the idea that they might get a lesser case of smallpox and then come out the other end with lifelong immunity. The problem here was not about individual rights and people exercising them, but rather that people were violating community norms. And so in the 1760s and 70s, there are a range of riots around smallpox inoculation, largely around the idea that not everybody could afford to be inoculated. It was expensive. And that the people that were inoculated, who might feel well before they were still safe to be in community, they'd walk around and maybe infect others, they were dangerous. And so riots broke out, including big hospitals that were burned down by ordinary people that felt that certain people could not be singled out for special treatment here. Either everybody could get inoculated or nobody could. That was the general sentiment. Now, there's a legacy here to attend to from New England in the 17th and 18th centuries, reaching into the 19th century, even though we think of this era as one dominated by laissez-faire economics in many respects, and the emergence of a new kind of capitalist order. In fact, governments were able to order again and again provisions around the public health, limiting business opportunities, demanding that people adhere to public health ordinances, trumping, in other words, what might be thought of as individual liberties. And they did that in the name of the people's welfare. And there's been a lot of writing about that. There's another legacy to this, which is that the federal government did not get especially involved in in public health, and it really kicked that off to the states. And we could talk more about that later, as I see my time's running out. And the final comment I'd have here is that I think the community of perils might be something interesting for us to reintegrate into our vocabulary, if I can be bold enough to say that. That is, it helps us understand, when we're debating about something like that one needs to get the vaccine in order to free up hospitals so that people that don't even have COVID, say heart attack victims or cancer sufferers and so forth, have room. This is very much in the spirit of something that New Englanders would have understand. The world of suffering is broad and wide and capacious. It needs to involve us all in each other's interests and pursuits. Thank you.
Thank you, Ben. Thank you, Professor Mutchler. That was great. I'm keen to hear what our next speaker has to say about this rhetoric of the community of peril or perils. Coming up next is Courtney Campbell, the Hundair Professor in Religion and Culture in the School of History, Philosophy, and Religion, another great collaborator on this series and several other series. He's the guiding force behind the very popular medical humanities program, among many other credentials related to our topic today, helped to spearhead the return of the vibrant religious studies major at OSU. Among his courses of relevance to our panel are classes on biomedical ethics, death and dying, and pandemics. His most recent books are Bearing Witness, Religious Meanings in Bioethics, Cascade Books 2019, and a book just out that I haven't yet seen, but I was excited to see being published, Mormonism, Medicine, and Bioethics from Oxford University Press in 2021. So without further ado, please help me welcome Professor Courtney Campbell. Thank you.
Thank you, Chris, for your introduction, and I appreciate being on the panel with everyone. I'm going to take, as Chris indicated, a little bit of a different approach, given my sort of specializations in ethics, in ethics of healthcare in particular, as well as sort of philosophical ramifications of questions about rights and responsibility. Rights discourse, as we know, sort of pervades our contemporary life and our contemporary civic discourse. It is a problem in respect to the historical background of rights language, which presupposes adversarial relationships and presupposes relationships of power of an oppressed group or an oppressed person vis-a-vis a greater power, whether it be a political power, medical power, religious power. Rights language presupposes adversarial relationships and relationships of power or unequal power. And so it deserves 2 chairs, but not 3. Rights language is necessary, but it's not sufficient for a society that aspires to form a more perfect union. That's going to be the basis of my argument. Now my discussion. Now you might have seen this earlier this week, this headline at the top, which is drawn from a CNN site, that 17 healthcare providers, some were Catholic, some were Baptist, cited religious reasons seeking to prevent New York State from enforcing its vaccine mandates for healthcare providers. I mean, it's one thing about citizens, but these are healthcare providers, presumably seeking to provide care for the rest of us. And they're saying, no, we don't want to get mandated because the vaccines or the mandate violates religious liberty. The vaccines, so they argue, were based on research that had to do with embryonic and fetal tissues generations ago in the fetal cell or the cell lines. New York judge has currently upheld that. There's still to be hearings about that, but there's certainly a claim there of a personal right that conflicts with broader professional responsibilities and broader duties to the common good. In this particular case, the plaintiffs have argued in their presentation to the court that the New York mandate is unconstitutional and unlawful. And so we want to take seriously their claim about why it would be unconstitutional here. As you can see, New York is one of 5 states in the gray that does not have any exemptions from vaccination for non-medical reasons. All the states have reasons or exemptions based on medical reasons, but those in the light blue have both religious exemptions and personal belief exemptions, like Oregon, and those in the dark blue just simply have the religious-based exemption. And so, again, New York is one of the 5 states that doesn't currently have a religious-based exemption, and so the plaintiffs are claiming that this is unconstitutional, that we're not allowed to, as healthcare professionals, we'd be subject to this mandate for the COVID-19 vaccine. So let's query that a little bit. I'm not convinced that their claim stands up. It's important to think, and Ben discussed this a little bit, it's important to recognize that the founders did not think that as much emphasis as they put on personal rights and liberties and protection of the person against the state, that those were not antithetical to civic responsibilities or civic duties or the duties of towards the community. You think about Washington's farewell address, for example, that he argues that political prosperity requires the indispensable supports of religion and morality. That is to say that you can't set up a political culture only based on political rights against the government and expect to have a flourishing democracy. Because rights language presupposes relationships of power and presupposes adversarial relationships, a political culture that's based exclusively on rights will engender mistrust and adversarial relationships. Washington argued in that address that it was necessary to have religion and morality around because they were necessary supports for what he called the duties of citizens. In particular, and this runs through all the founders, a sort of culture of civic virtue in which the citizens, not because there's a necessarily governmental mandate, but the citizens are inclined in their character to promote this general welfare. And the first really primary illustration of this effort comes in the 1813 Act to Encourage Vaccination. Just a brief history, Ben touched on a little bit, but Jenner had developed the smallpox vaccine in 1796 from cowpox variation. By 1798, some supplies of the vaccine, smallpox vaccine, make it to the United States, which has undergone, as already indicated, several kind of smallpox epidemics and outbreaks thus far. Thomas Jefferson, who is not yet the 3rd president, but engages in his own studies of the efficacy and the safety of vaccine. And by 1802, everyone in Monticello, his family, slaves, and so forth, all have been vaccinated against smallpox, a scourge at the time. And he says that medicine has never before produced any single improvement of such utility, and says later in 1802, to give this discovery the whole of value, we should enable the great mass of the people to practice it on their own families and without an expense. That is taking up one of the issues that Professor Mutchler referred to about the cost of previous forms of inoculation. So the 1813 Act to Encourage Vaccination, which was passed in the presidency of by Congress under James Madison, seeks to do exactly that, to provide a free vaccine for tens of thousands of people each year. It was really the first government entitlement, healthcare entitlement for the for the general population. And one would hope that that might have continued, but 8 years later, excuse me, what's referred to as the Tarboro tragedy occurred when in Tarboro, North Carolina, they received some stocks of vaccine that had inadvertently had live smallpox scabs. Those were injected into individuals. Some 10 people died. Another 60 people were sick. And as a result of this accident, is an inadvertent mistake made by the national vaccine agent, Dr. James Smith, Congress repealed the 1813 Vaccination Act, or the Act to Encourage Vaccination, and would not take it up again for 80 years until the start of the 20th century. And that meant that the United States lost several thousands of lives to a disease that European countries, again with a greater emphasis on the common good, had made vanishingly rare. So this ultimately comes up yet again in 1904. The context is a smallpox epidemic that had afflicted the Northeast, particularly Cambridge, Massachusetts, and Cambridge had passed an ordinance that persons must be vaccinated mandatorily against smallpox. If one objected to that, then one would have to pay a small fine. They weren't going to hold a person down to give the smallpox vaccination. And Henrik Jacobson, an individual that was a Lutheran pastor, he had an experience with smallpox when he was a young boy in Sweden, and objected to this on grounds, objected to the mandate or the Cambridge Ordinance on grounds that, to go back to a couple of the rights that Rory referred to, that it violated the security of his person and violated rights of equal protection without due process of law. So the question ultimately gets appealed to the Supreme Court, and in a 7-2 decision written by John Marshall Harlan, who's probably more famous for being a dissenting vote in the Plessy versus Ferguson case, which ratified segregation. Marshall Harlan was the lone dissenting vote in that particular case. The Supreme Court upheld the compatibility of the Cambridge Ordinance and the responsibility of citizens to promote the general welfare, even if that meant some infringements or restraints, is the language that Harlan uses, on personal liberty. There were three major questions that come up in this case, just to be very quick about it. First, is liberty an absolute right? As Rory already indicated, no, the courts have never interpreted any form of liberty to be completely absolute. Harlan wrote, the liberty secured by the Constitution of the United States does not import an absolute right to each person to be at all times and in all circumstances wholly freed from restraint. Second question is, if we accepted liberty without limits, what would be the social implications of this? If everyone wanted to do as Henrik Jacobson did, what would be the ramifications for society? Harlan wrote, there are manifold restraints to which each person is necessarily subject for the common good. On any other basis, organized society could not exist with safety to its members. Society based on the rule that each one is a law to himself would soon be confronted with disorder and anarchy. Given those critiques and the need for some kind of restraints on liberties, what circumstances may, in Harlan's words, a well-ordered society impose restraints on personal liberty? And Harlan, in the decision, under circumstances when the well-ordered society, and what that is an important kind of question, was facing a paramount necessity and great danger. Under the pressures of great dangers, the rights of the individual in respect of his liberty may at times be subjected to such a constraint enforced by reasonable regulations as the safety of the general public may demand. Very important case. That might be a case that will look pundits think will be looked upon at precedent when some of the other challenges to vaccines are heard in under the Biden administration. So just a couple of concluding comments then here. To mandate something does not get, obviously, the inculcation of civic virtue, which the founders, I think, were supportive. So again, civic virtue is the inclination of individuals to promote the public good without being mandated by law or coerced by law, if you will. But it comes instinctually because of their connection to the general welfare, the promotion of the general welfare. So again, my points here, just briefly, that political legal rights, such as those that Rory referred to, including religious liberty, are a moral minimum. They're a standard that's necessary for civil society, but insofar as they presuppose relationships of power, relationships of oppression, and relationships of adversaries, they do not exhaust our ethical responsibilities. So moral minimum, but not adequate standard for a democratic or Republican society. Rather, the moral and religious and cultural traditions that pertain to sacrifice, to solidarity, to neighbor love, to care for the vulnerable, support a broader civic virtue or a broader civic duty to promote the social good or the general welfare. There's an argument that I can spell that out, but I'm not going to do that right now because of time. And just conclude that no religious denomination is formally opposed to vaccination. The religious exemptions that are being claimed are sort of individual interpretations of religious or non-religious values. And when an individual claims a personal religious or personal belief exemption, saying my liberty would be unduly infringed by acquiescing in this requirement or this mandate, I think that needs to come with some discharge of civic responsibility as well, whether that's contributing to reading books to kids at the library or serving at a soup kitchen or something like that. If you're going to claim a religious and personal belief exemption from a vaccination mandate that is seeking to promote the common good, you have to find some other way to discharge your civic responsibility. Okay, I'll end it there.
Thanks very much, Courtney. I really appreciate where you ended, in fact, and I think it will dovetail well with Paul's presentation to come. Paul Thompson is an associate professor of economics here at Oregon State University in the School of Public Policy. His research interests include public economics, the economics of education, urban economics, the effects of the 4-day school week, financial intervention systems, changes in local and state funding for K-12. He's written extensively on a number of those topics, including financially troubled school districts and local governments. His work has been featured in outlets such as the Journal of Urban Economics, Economics of Education Review, Regional Science and Urban Economics, Journal of Educational and Behavioral Statistics. And he'll be tackling some of the questions that Courtney was getting to in terms of bioethics and civic responsibility. So without further ado, I'll turn it over to Professor Paul Thompson.
Thanks, Chris, and thanks everybody for joining us today. So I'll be kind of dovetailing on what everybody else talked about today, coming from the lens of economics, right? When we have this kind of dichotomy of individual rights and this collective responsibility, why do we see kind of this contentious debate over things like mask wearing or vaccines? And what can governments do, maybe beyond just mandates to kind of elicit responses maybe we want to kind of promote this collective responsibility, right? So when we think about competing views that we see in the news, debates over mask wearing, vaccination, recently. We see this in a lot of cases of government intervention, maybe more so today than in the past. But it's kind of these two competing views. One, we see this idea that people are kind of making decisions based on their own personal preferences, their beliefs about what's their given rights, under the Constitution or perceived rights, like we already mentioned. And this idea of kind of libertarian paternalism says that government intervention is kind of imposing its will or its preferences on those individuals who kind of have this right to kind of make decisions for themselves, right? So like these people here are saying we don't need vaccination, we don't need the government kind of controlling our decisions. Right, on the other end of the spectrum, right, we have this kind of individual failures type approach that says, well, people aren't always making the best choices for themselves or for society. And so we really need government intervention to help people make socially optimal decisions, right? Some people maybe are taking into account kind of this, collective societal benefit, like we see in the sign here. I'm getting my vaccine because I want to protect my community, but not everyone is maybe doing that, right? So when we get this kind of contentious debate, we often see these two approaches, right? One, we're saying the government is overstepping its bounds, or it's infringing on my rights. Another is saying, well, we actually need government intervention to help people kind of make those good decisions. Right, so when we think about collective action, related to vaccines or mask wearing or just in general, often this kind of in economics we think about this as kind of externality problem, right? Where people are making kind of these personal choices, about their specific action or consumption decisions based on kind of benefits and costs of that decision to themselves, right? Not everybody is taking into account, protecting their community when they think about, should I get a vaccine or not, right? So not, some people may, but not everyone is going to be taking into account kind of the impacts or, the external impacts of these decisions on other people in their community or society at large, right? And so this is, a problem that's kind of just been, at a much larger scale when we think about, the COVID crisis, issues of collective action as a way to kind of stop the pandemic. And so what happens when we have a personal action or decision that does affect others in society, right? So, the basic economics, idea of kind of externalities is this would lead to a socially suboptimal level of take-up of collective action, right? So we've seen this, in the current crisis, seen this likely in past examples as well, where you might see, a healthy person saying, I'm not getting really any direct benefit of the vaccine for myself. If I got sick, I probably would be okay. So I'm not going to choose to get the vaccine or wear a mask because that's viewed as kind of a cost to me. right? So, if they're not taking into account any of these societal benefits of, protecting your community, this kind of collective action, we're missing out in that decision, these kind of societal benefits that might be very high, right? And so if people took those kind of external benefits of, the choice to get a vaccine or wear a mask, we might expect take up to be much higher, right? And so, you can see in the graph here, take up for the US, much lower than we see in some other countries. And this kind of gets at the crux of what we've seen recently in terms of, questions of what should we do to try to increase this kind of stalled take up of collective action, right? And so, what can we do to, help people kind of take these external benefits to society into account, essentially kind of internalize, right, this externality into their decision making. And we've talked about this mostly today, right? Government interventions are a way to try to change people's behavior. And again, we've seen issues with people thinking that maybe government intervention is kind of overstepping and infringing on rights maybe protected by the Constitution. Right. So when we think about interventions, what can we do? Right. So a lot we've talked about today is kind of the second point, right? Kind of these mandates. Those have potentially high administrative costs, potentially the ones that are most problematic when we think about court challenges related to religious exemptions, other things we've heard about today. Where again, you're being required to get a vaccine or conduct testing to be able to do things you've done in the past, like go to an event or go to school or work. And so this type of approach to government intervention, right, that's going to increase cost to unvaccinated individuals. If we're talking about vaccination, it's going to increase the benefits of vaccination because you're able to actually do these events. If you're unvaccinated, well, now you have to incur the cost of getting, weekly or daily testing, depending on, what context we're talking about. And so we've seen this with, the recent, Biden mandates. We see this on OSU related to, OSU events. If you want to go to Reser, watch a football game, right now you're either showing a test or a vaccine, and that's going to, infringe on your ability to go to that if you don't want to incur that cost. And we've seen this, in cities as well, right? New York City, we heard about, the court challenge there. Seattle has also, recently adopted a new indoor mandate for vaccine or testing as well. Right. So it seems like most of the contention right now related to rights, individual rights, religious exemptions is coming from mandates, right? But that's not the only type of intervention we have, right? We've heard about, information interventions, right? So sometimes, people are failing to kind of make these socially optimal, collective action decisions because they just lack full information about what kind of the external benefits of that choice are. Right. So, things like ad campaigns, historically, we heard about this, right, in the newspaper saying, this is why we're doing this. It's helping society at large. Those can be kind of informative to, give the full scope of benefits to people. Right. We heard that, with things like, the stay-at-home order, right? You listen to the radio or watch TV, right? There's ads all the time, like stay home, save lives. Those campaigns can help try to give people some sense of, right, again, eliciting that civic duty that we heard earlier, right? But, in today's day and age, right, another issue is misinformation. And so, government action could also kind of target combating misinformation and providing information that's actually useful to people to make these kind of individual decisions. And then a final piece of the puzzle here are price policies. So these are not saying we're going to mandate that you get a vaccine or take up this collective action, but we're going to try to either incentivize people to take up collective action by lowering the price or cost of doing it, or increase the cost of not taking up the collective action. So we've seen this, both of these in regards to recent, COVID vaccination. Making the vaccines free hasn't fully worked, right? So generally, we heard historically, right, vaccines were too expensive. This is one reason why people chose not to take up the vaccine historically. Now, right, the vaccine is free, accessible to everyone, but we still see kind of low rates of vaccination, right? So there's something else at play here, other types of costs associated with take up, perceived costs of, I don't know what this is going to do to my health, side effects, things like that are kind of being brought into the equation, right? So subsidies, might be a way to kind of combat that, essentially giving these vaccines kind of a negative price, right? So we've seen things like you get a vaccine, you get free stuff, right? So, Krispy Kreme donuts, we've seen vaccine lotteries. Recent evidence that you can see here shows that, the dark blue line here is, Ohio that had a vaccine lottery. Somebody was going to get $1 million if you got vaccinated between, certain parts of May and June. And we see higher levels of vaccination in Ohio relative to places that didn't have a lottery. And that does seem to have reduced the level of infection, the level of people, spending nights in the ICU. So, some of these subsidies have worked. So that's one potential way to, change people's behavior related to collective action that doesn't involve maybe mandates that would lead to, court challenges. Right. The other way is, some sort of, quote unquote, unvaccinated tax, where, unvaccinated individuals are going to have to pay higher costs to compensate for those external costs they impose on society related to overwhelming the healthcare system, more medical costs, things like that. We've seen a recent example of this, right? Delta Airlines had a policy where unvaccinated individuals would have to pay more in healthcare premiums if they chose to remain unvaccinated. But this is similar to things we see if you're a cigarette smoker, you're paying a little bit higher price on your healthcare premium to compensate for those increased healthcare costs. And some recent evidence has shown that there was about a 4 percentage point increase in vaccination among kind of Delta Airlines employees as a result of this policy, right? So price policies seem to be working, even if the changes are rather small, but again, might be less contentious. It might be a way to kind of bridge the gap while we wait for some of these court cases related to mandates to shake out. And thank you.
Thank you very much, Paul. Thank you to all the panelists. And now we'll just have a discussion. We will end at 5:30 p.m. Pacific. I saw a few questions come in. If you have more questions for us, by all means, toss them at us. We're ready to take anything and everything. One of my questions to the group, which I think we've all been hearing in this talk, and I wish the series of talks, and I wish we could get this out to more people, was about what kind of different models are there for understanding the relationship between individuals and collectivities? One of the things we've been hearing, ending with Paul Thompson's comments, which strikes me are really useful, is that in an era of affluence, we seem to need, at least in the US, to incentivize through direct funds in some way, right? That civic responsibility in the way that Courtney Campbell was talking about it, or the general welfare and the community of peril, the way that Ben Mutchler was talking about it, or even conflicting rights and responsibilities as they've been understood over time, seem to have changed in the context of the affluence of the modern US. Perhaps that is partly because people don't experience suffering in the same way, or are not as used to, say, 17th and 18th century New England, seeing affliction all around them. So I wondered what you all think about this, just returning to this kind of core question. Are there different models for understanding the relationship between individuals and collectivities? Or are there just so many that they're mind-boggling here, and in particular, maybe with our lens on the Constitution, but recognizing the limits of the law here? I see Professor Solberg. You want to jump in?
Well, I was just going to say that one thing that's really clear is when you look at our Constitution, particularly comparing it to constitutions of other Western democracies, or other democracies, we don't actually have much in our Constitution, if anything, regarding social responsibility, regarding civic responsibility, regarding your duties as a citizen. right? So it's all about, here's the powers of government, here are your individual rights, which we talk a lot about in the United States, but there's not anything about your responsibilities, right? Even the right to vote is considered a right and a privilege, not a responsibility, not a duty. We don't talk about it in that way. But when you look at other constitutions, they actually have sections that are on, here are your duties as a citizen, right? So here are your responsibilities codified to the collective. And that's something I think that developed after us, right? After our model of constitution, which I think is pretty important and something that we're missing if we want to sort of think about it that way. That allows people to think only in terms of their individual rights versus others. But I will cede to Ben, as I see his hand is up.
I was just going to say historically, right, and Courtney addressed this, while those sorts of imperatives were not written into the Constitution, the whole debate around that is filled with people talking about what's going to be necessary for this to work, and great fear that it won't work in the absence of a lot of goodwill, of learning, of sacrifice for the good of the whole. Much worry about people being too selfish for this to work. At the state level, those constitutions, many of them have what Courtney was alluding to, a sort of moral instruction, thinking about religious instruction, that's part of them. The part of the separation of church and state has the federal constitution not doing that. But in the era, if we can recover our founding and not take this in a simple way, just that the founders, sort of forward ho and we're off to the races, but really think about what they were asking of the people at the time, I think that might be a good place to start. Nobody had a notion at the time that sort of just following those rules, vague as they were, stipulated in the Constitution, was going to cut it. There needed to be some great sense of sacrifice and effort to make this work, and many of them thought it would not work.
Yeah, and I'm not suggesting that that was the case at the time of the founding. I'm saying that today, when we have today's discussions, right, and people think about the Constitution, it's very individualistic, and then they go to the Constitution to say, see, look, right, here are my rights, and there's nothing there that encompasses the gestalt of that time that was just understood, right? Like so much of it was understood, and now we've lost that.
That's right. And tracing how and why that happens, and that sort of denuded value that was part of this initially, seems to me that's an important project. Yeah.
Courtney.
Yeah, very important discussion, and descriptively, I mean, Rory's exactly right. There's nothing really in the Constitution per se about personal responsibilities or civic responsibilities, and there's a reason for that. We know kind of what the reason for that is. And the argument, I mean, you asked initially about the relationship of the self and the individual and a collective. I mean, the Constitution is drawn from Locke and Hobbes and others, Rousseau, where the individual is rather atomized relative to the public welfare and the oppressive state. Again, it's premised on an adversarial relationship of oppressive power, or trying to protect the individual from the oppressive power. Now, there's different ways that one can configure the relationship between the self and the state than just adversaries and so forth. But that is the assumption that rights give you weapons against the overbearing oppressive state. The point that Ben was making, I tried to make as well, is the founders recognize you need to fill in the gaps or the chasm between the atomized individual and the broader public good, or this whole thing will just kind of, implode. And so, at least for Washington, there's the appeal to religion and morality as necessary supports for political prosperity. You get the appeal in both Madison and Jefferson to notions of civic virtue, inclinations that would be instilled in the populace through various forms, could be religious, but also moral education, just political involvement. as well, an inclination towards the common good. But that is, and Ben and Roy have pointed this out, that's an extra constitutional project. Okay, you're not going to find it in the constitutional document that we have. You have to go beyond that, and you have to engage in sort of what Robert Bellow refers, sort of a sociological project of cultivating habits of the heart.
And there's another dimension. There's several other dimensions there. Where one of the things we're living in this moment that we haven't really touched on yet that gets at this is emergency. The Constitution doesn't explicitly detail emergency powers, but it's implied, generally speaking, that the president has, or the executive branch has, emergency powers, and that's been held up mostly because the executive can move more rapidly than the legislative branch. And when you look to the 17th, 18th century and the powers of government in emergencies, be they natural emergencies or wars, you get to other really interesting sets of questions, right, about what the state can do or not do. And this brings me sort of to a question to Paul here too. One of the things you didn't mention were externalities or incentives related to punishment, explicit punishment. So in 1918, there were very few mask deniers. In fact, there was one case, a big case in San Francisco, the Anti-Mask League, but it was just a few thousand people. But a number of folks, you can read the journalists on this, when they got thrown in jail or had to pay a large fine, they changed their views and they wore masks. Are there any hopes, or are there any studies for how penalties, more than incentive structures, and different ones, you talked about pricing, you talked about taxes, you talked about mandates, right? Different forms of types of costs. Are there any studies that suggest that maybe a higher bar is useful, or is it more like questions of, say, capital punishment, that it seems like there really isn't that much of a deterrence factor there?
Right. I think, that's the other side of the coin, right? With these, price policies or things, right? Levying a huge fine, I think we see that in other instances, right? Levying a huge fine if you're, caught driving, erratically and things, right? And seeing people change their behavior in those ways. Given, just, how, dichotomous the, groups are in terms of, people that really want these, government interventions to happen, people that are really vehemently against them. Things like incentives seem to have a little bit better, I guess, public sentiment these days than maybe something where we're going to say now you're going to have to pay a huge fine. Might see kind of similar vitriol against that as you see kind of with mandates these days. And so why the incentives seem to be working well, maybe is just that price is something that matters, but the framing of those price policies and framing them in a positive way is something that people are responding to well, versus mandates or fines.
Dear Rory.
Yeah. And the other thing I was going to say is that the difference in the two time periods, we have to realize that, for the 1918 pandemic, rights weren't incorporated down to the states. The states didn't have to follow the Bill of Rights. We didn't have the language of rights that we use today. We didn't have the culture of court challenge, right? So today, if you put on this mandate and an individual and you say, okay, this individual is going to be fined, right? Previously, they were like, okay, I changed my mind. I don't want to pay the fine. Now you've got interest groups that are going to come in and say, we'll take care of the fine and we're going to challenge this case for you, right? And so there's this, it's a very different dynamic in terms of, of how people will respond. I think that probably changes that calculation quite a bit, right? Because you instead of, oh, I don't want to pay this fine, you say, well, now I've been even more wronged, right? Now I have even more to challenge.
Yeah, and especially in an emergency versus some folks have mentioned the analogy of seatbelt laws or required car insurance, right? But this is not the temporality of that is extending into the foreseeable or infinite future, whereas in this moment, vaccines are a much more limited duration kind of problem and question.
Right. Yeah, and you also have the problem with the vaccine and the mask mandates. People are they're finding ways to tie it to individual rights, and it's harder to tie a seatbelt law, I think, to an individual right. Although people have, I have the right to risk my life, right? I have the right to do such things. They've made those sort of same arguments. but there is a long history in our country of, the right to refuse medical treatment. So having a vaccine imposed upon you, you can make that connection more securely than you can with, say a seatbelt law or a helmet law of those. But we still see some of the same reaction today to helmet laws and those sorts of things.
I see some more philosophical questions coming through about questions of civic virtue in the founding era. Were they seen all the same way across the original founding states? What do we make of how they were drawn from Christian virtues in Rome, as well as the Enlightenment kinds of principles that you all were talking about? And then I might add, does that inform in any fundamental way what we're talking about with the Constitution, or is that actually, to paraphrase, the past is a foreign country and that really resides in the past? This is sort of at the intersection of Courtney Campbell and Ben Mutchler's comments.
Well, I'll just speak up very, very briefly. So there were various sources for the concept of civic virtue. Again, some drew on sort of classical sources, others drew on Christian sources. For Jefferson, civic virtue was connected with the virtues of farming the land, of the agricultural ethos, not of the political elites, not of really of the educational elites. It's very Monticello, I guess, but again, it was the civic virtue was inculcated by working the land by nature. Anyway, the point is you get some very different kinds of appeals, some very different kinds of arguments. There's certainly not, a unanimous interpretation. The important point is that the founders said that you have to have something like this or this, remember Benjamin Franklin's response, it's a republic if you can keep it. If you don't have something like civic virtue in play in the society to sort of balance the rights language and the adversarial relationships, it's going to be hard to keep the republic. So there's a kind of extra constitutional context for what we find in the Bill of Rights and individual liberties.
If I could just chime in here, there's all sorts of invidious distinctions that are made at the time. There's a gentry class that believes that those that are sort of ordinary folks may not have the means to be as virtuous as the elite. There's this celebration, as Courtney says, of the agricultural life by Jefferson and others, and at the same time, a kind of fear of what happens in the city, the corruption of living there. And Jefferson spends so much time trying to avoid that in the building of cities. There are Northerners that look at Southerners and say that the Southerners don't have the civic virtue and they've been dissipated through enslavement. And Southerners who look to Northerners, especially after the Revolution, and say that the wage slavery of the factory is itself a source of dissipation. So, that comment, which is, I guess I was trying to find the original person who said that, Georgia asked, I'm sorry, I don't have the last name, is a really good one. I second Courtney in that there needs to be, or one kind of remedy here could be a greater familiarity with the discussion at the time, in some sense that missing this piece of civic virtue, the Constitution cannot survive, nor the Republic. But then to also know that it's complicated historically. There's not one agreement about what this is and who can possess it and on what terms.
That's a great way for us to kind of encapsulate the panel. I'm always cognizant of the time. One of the things I just would want to wrap us up to think about and synthesize is, as I heard the flow of the conversation go, it strikes me that we move from a kind of vision of conflicting rights and the importance of context, right? Who's on the court and what sort of is going on in culture at a given moment, framing this fundamental debate, not as so much as a binary, but really as a set of interpretive problems, that in fact, as we move through thinking about, the long trajectory of these questions that precedes the founding of the US, this kind of concept of a general welfare has changed somewhat. And that, we're in a moment now where that seems really quite distant from an era in which the federal government or state governments even asked a lot, an enormous amount, as Ben Mutchler said, of citizens, right? And this is what all of our Q&A has now revolved around. How do you structure it with economic incentives? What kinds of values should you have there? What should the sorts of legal remedies be? And then if you think through, and I would really appreciate Courtney Campbell's comments here, I wish most Americans had a sense of this trajectory as well. What was going on with vaccination? I often refer to this as an American tradition of vaccination or inoculation. And if you combine Mutchler's and Campbell's comments, you get to the fascinating point where Americans actually objected when vaccines were fundamentally unequal. They wanted them to be equal, right? That's a fascinating difference from now when they're free, as Paul Thompson was saying, right? They're free, and yet still we have to pay people to take it. And so that's the world that we live in today. And it's some of the comments that are still coming through are noting, if individual choices have collective ramifications, how do we grapple with that? Through our disciplinary knowledge, through our efforts as engaged members of a community. But then what? What happens when you come up against the brick wall of the fact that some members of a community simply won't do what's in the general welfare, whether it's the 17th or 18th century and today? In the 17th or 18th century, as Ben Mutchler said, people would have been locked in their homes and would have been forced to pay for their treatment. That's off the table in 2021. Should it be? Is maybe an open question. And the first question that came in was, should there be a new constitutional convention? That's a nice way to leave Constitution Day 2021. And maybe we'll come back around to constitutional conventions in 2022. Thank you all for being with here. And special thanks to our great panelists who've given us a lot of time and terrific food for thought. Thank you all very much.